This is the Guidance for Commercial Tenants During the COVID-19 Pandemic webinar. So this webinar is brought to you by the City of Alameda in partnership with the Alameda Chamber of Commerce. So I want to just take a minute to introduce Madeline Sadek, who's here. She's the President and CEO of the Alameda Chamber of Commerce. Also in attendance from the City of Alameda in the Community Development Department is Eric Fonstein. And with that, I'm going to introduce our presenters today. First, we're going to hear from Wes Chung. He's the Deputy City Prosecutor with Alameda City Attorney's Office, and he's going to be talking about Alameda's commercial eviction moratorium. Next, we'll hear from Neil Rubinstein. Neil is an attorney, a SCORE counselor, and the chair of SCORE East Bay. He's had a 38-year career practicing as an attorney, working with banks and other companies on a wide variety of finance, business, and real estate matters. So Neil is going to present on kind of guidance for managing commercial lease negotiations during COVID-19. In addition to Wes and Neil, we also have Ted Anderson here from Cushman & Wakefield. Ted is a licensed commercial real estate broker with over 20 years experience in commercial real estate, and he's going to be participating in the Q&A session. And with that, I am going to hand it over to Wes to give his presentation.
Thank you for the introduction, Amanda. And I want to welcome everyone. I think this is a very important topic, and I think hopefully it'll be informative. So again, my name is Wesley Chung. I'm with the City Prosecutors or City Attorney's Office. I'm the Deputy City Prosecutor. And what I want to do is to kind of give an overview of both state and local laws. That way y'all could be informed when you do enter these negotiations. So let me share my screen. So when we talk about commercial evictions, when we talk about commercial evictions, it starts with a baseline, and that baseline is the state law. Now, the baseline is that the state law prohibits local governments, such as the City of Alameda, from enacting rent control for commercial tenancies, and that's the baseline. So ever since the COVID pandemic began, Governor Newsom has essentially enacted a executive order. That executive order is N2820, and what that does is that lifts that state law prohibition, allowing local governments to enact local ordinances to control the rental and the tenancies, the commercial tenancies. With the suspension of the state law, the governments can essentially pass these protections that normally would be reserved for residential tenants. But the source of our authority to pass and enact these local ordinances is that lifting of that prohibition. So up until this point, without that executive order lifting that prohibition, we can't do anything. So far, that order has been renewed at least 3 times, but so long as the order remains, we are able to enact these local protections. That being said, the second that order is no longer renewed, even the protections that already exist, they are essentially invalidated because the state law preempts our local protections. So that's the baseline. The baseline is the state law prohibits local ordinances or local governments from enacting, and passing ordinances to regulate commercial tenancies. But the executive order N2820 lifts that prohibition and allows us to do that. And so long as the executive order N2820 continues to be renewed by the governor's office, we can continue to provide these types of protection for our commercial tenants. Now, the Alameda law that's on the books, specifically it's Ordinance 3275. And when we get questions about the eviction moratorium, the people are really asking 2 questions. The first is, if a landlord serves me eviction papers, what can I do about it? That's really the main question. Can they serve me eviction papers? And if they do, what can I do about it? So the answer to that first question, the simple answer is yes. There isn't really any prohibition that prevents a landlord from serving you with papers. So the term like moratorium on eviction is more of a colloquial term and a common layman term, because not the actual eviction process is not forestalled, so to speak, and the landlord is able to serve you papers. Generally, only the state legislator and the courts and the governor can authorize a moratorium on evictions. The local governments really don't have a say in that matter. For those of us living and working in the city of Alameda, we don't have the power to unilaterally stop evictions from happening. But that being said, what we can do is pass these ordinances to kind of give commercial tenants a layer of protection that they can access if they prove certain things pursuant to the ordinance. So that ordinance that that has been enacted by the Alameda City Council is 3275. You could find out more information on this on the City of Alameda website under tenant resources. But what ordinance 3275 does is that it provides commercial tenants the affirmative defense to beat an eviction proceeding or unlawful detainer proceeding, if they are able to show certain factors, certain things, and prove up certain things. And those certain things are essentially a substantial loss of income as a result of the COVID pandemic, and that the eviction is for a non-payment of rent. If you're being evicted during the pandemic as for something that's unrelated, say like you did something illegal, Ordinance 3275 does not give commercial tenants that affirmative defense, even if they can show they suffered that substantial loss of income. So that's the thumbnail version of 3275. But it's important to note that what 3275 does and what 3275 doesn't. So as I indicated, what 3275 does is it provides that affirmative defense that if a commercial tenant can prove in court, can beat the landlord action. But what it doesn't do is it does not alleviate or it does not prohibit the landlord from actually serving papers on a commercial tenant, nor does it alleviate the tenant's obligation to pay rent. So going back to my initial comments at the top of the segment is, if a landlord serves you papers, or can they serve you papers? Yes. But once they serve your papers, what can you do about it? Well, you could either fight it using the local ordinance affirmative defense, but whether or not you could prove it up, it's going to be determined based on your own circumstances. Or you could kind of work out something with the landlord. And we do have resources on the City of Alameda website. If you go to the Tenant Resources tab, you'll find a form that you can fill out with your landlord that essentially establishes a kind of a informal agreement on how and when to pay back any kind of back rent. Now, those negotiations are very case specific, and I'm sure the rest of the panel will discuss about the procedures of doing that. But as far as the interactions go between state and local law, again, we have that baseline prohibition that is lifted due to the executive order, and that opens up the City Council of Alameda to pass laws like 3275 to protect our commercial tenants. So that is the state of the law as it is. And for those who are interested, keep on following the executive order N2820. The most recent renewal, I believe, occurred in September. And to the best of my knowledge, it's set to expire of March of 2021. So as far as the Ordinance 3275 continuing to protect tenants, it should do so until March of 2021.
Thank you, Wes. So we're gonna turn that over to Neil now. And folks who might have joined us a little late, please put your questions in the Q&A function at the bottom of the screen, and we're gonna have a Q&A session after the presentations.
Thank you, Amanda. I'm going to put up some slides. Oops. Okay, can everybody see that? Amanda?
Yep, we can see it.
Okay, good. All right. Thank you. As Amanda said, my name is Neil Rubinstein. I practiced law for 38 years, most recently as a partner in a San Francisco firm. I retired about 5 years ago, and I've been doing some volunteer work as a business counseling for East Bay Score since that time, as well as some other things. During the course of my career, I worked a lot with commercial leases. As Amanda said, I've represented banks and commercial and real estate finance matters, and commercial leases came up all the time. And one of the things that I want to talk about today is kind of talk about some of the practicalities of dealing with commercial leases and from a tenant perspective in the coronavirus pandemic situation. And what I'm going to do is I'm going to be approaching this from a tenant's perspective. Basically, we're seeing a lot, and probably a number of you in the audience fall in this category. If you're a small business, you have a long-term lease that has several years or more on it. Your business is doing poorly given the economic situation and the COVID-19 problems. And your landlord has not come to you and offered any concessions on your lease. Landlords tend not to take the initiative in giving concessions to tenants. And so you as the tenant are thinking, what can I do? What rights do I have? And Wes gave a really good description of the legal preclusions from being evicted during this time. But most tenants really are not looking to win a lawsuit in an unlawful detainer or an eviction proceeding. What you want, and you don't want to get into a big battle with your landlord if you can avoid it. So what we're talking about in this session, what I'm going to be talking about, and in the question and answer period following that, is maybe things that the tenants can do to try to work something out, hopefully in a conciliatory manner with a landlord, but in a way that allows the tenant to kind of get a better chance of getting through the current environment crisis. I'm going to be talking about kind of an approach of negotiation that's often referred to as interest-based bargaining. In other words, I'm not making this up. I mean, there's a basic concept of how you go to negotiate certain issues. And I'm going to be using that and applying it to the lease modifications situation, with an emphasis on kind of where we are right now, in which you've got this pandemic that is basically affecting everybody. There's basically 4 issues that you're going to want to inform yourself about before you actually start talking about modifying the lease, which I've listed here: what your goals are, the parties affected by the lease modification, yours and the landlord's rights and obligations if you don't make a deal, and what the landlord's objectives are out of this. And then that will kind of give you a framework for actually talking with the landlord to try to work that out. And I'm going to go through those one by one now. In this session, right now, I'm going to be kind of doing a bit of an overview because of the limited time, but we have a lot of time for questions and answers in this program. And so we can go to that in more depth. I know Ted Anderson, who's on the panel, is a commercial real estate broker and has a lot of hands-on experience in dealing with these issues. And so I'm quite certain he will have a lot to say on this, and maybe some of the other issues dealing with the lease modification issue. So the first thing you want to do as a tenant is figure out what it is you want. What's your objectives? And I'm not talking about the fantasy objectives like, oh, I wish this whole thing would just go away. It's kind of figuring out your business plan. I mean, what from a business standpoint do you feel you have a reasonable chance of accomplishing? And in order to accomplish that, what needs to happen with your lease? So one possibility is you may have decided there's just no way you're going to stay in business. I mean, it's you're operating a business that's doing really badly. You don't have a lot of financial wherewithal, and you've just decided from a business standpoint you want to close up shop. And maybe what you want to do is you just want to terminate the lease. I mean, just cut my losses. I've got a guarantee, hopefully limit my losses on the guarantee and get away from this. And that can be the best thing for some businesses. In other circumstances, you've got, you have some hopes that you're going to have successful business, but you need to modify the lease in some respect. That, having to pay X thousands of dollars every month is just killing you, and it isn't going to work. And so you want to modify it in some ways. And there are various ways you can potentially modify it. An abatement of rent means you get a period of free rent, maybe 2 months, 3 months, whatever. So, which is oftentimes is workable if you figure, I just have to get over this hump and then I should be able to conduct my business, but I just need some breathing space. Another possibility is a reduction in rent. I mean, that may be true with a lot of restaurants or places in which you're in business, but you're not getting as many customers as you had before. And so your revenues are lower, and you can pay rent. I mean, you're getting something, but you can't pay as much as you've been paying before because you don't have the income before. Maybe you want to delay payment of rent. In other words, you can, you're not asking the rent to be forgiven, but put off for some period of time. Or maybe there are other lease requirements. I mean, some businesses, like if you're in a shopping center, you're required to stay open a certain number of hours every day, or various other things that you want to change. And maybe given the public health orders, it may be impossible for you to do those other things. But maybe it's possible, but still not practical. And so it's kind of an issue of going through with the idea of your business plan, what it is you're trying to accomplish, and see how figure out how the modification of the lease may help you implement whatever your business plan is. Another kind of big one is reduce the personal exposure of the owners of the business. Small businesses oftentimes need to guarantee the lease. And so you may have a lease, but you as the individual owner or one of the owners has had to sign a personal guarantee. And it's one thing to have your business fail, but it's another thing to have the landlord come after your house or after your car or your personal assets. And so that can be, and often is, a very important consideration for a lot of small business owners, is how can I, in instance, reduce these risks? So that's kind of the first step. So, and so you're going through and you're figuring that out. Second step, figure out who would be affected by the lease modification. Obviously, you as the tenant and the landlord. But also, a lot of times with leases, there's a subtenant. They're going to be affected. If there are personal guarantors, they're going to be affected. The landlord's lender or the tenant's lender oftentimes are going to be affected because they're going to be requiring payments on the loans. There also sometimes are covenants that are, which are promises essentially in the loan documents that affect this. And this is often a very big issue for landlords, because if they have to, they may have something in their loan documents that say they have to maintain X% occupancy, in order to continue to draw on a line of credit, for example, or that they have to get certain revenues every month in order to be able to draw on a line of credit. And so they may have some constraints on what they can agree to you without violating this. So figuring out whose consent is required in order for you to have a lease modification, and kind of just figuring out who the players are going to be. Third step is understand the playing field. And by that, what I mean is, what happens if you don't have a lease modification? In other words, what are your rights and your obligations right now, and what are the landlord's rights and obligations? And so in that regard, this kind of falls in two categories. One category is the agreements. What does the lease say? And the lease will talk about how long the lease lands, when the expiration date of it is. If you want, for example, if you want to terminate your lease and the lease expires by its own terms in 6 weeks, there's really nothing to negotiate. I mean, you're there anyway. But there are issues also about rent. One of the things that a lot of small businesses do is when they negotiate a lease, they figure out the big terms, but there's all this boilerplate in the lease that they've never really read. And so now's the time to read the boilerplate, to see what it says and see, and do it with a mind of what your issues are. You've gone with those prior things about what you're hoping to accomplish, and go through the lease and see what in the lease applies to your situation. And you're probably going to be surprised. There's probably going to be stuff there that you never thought of before. And also if there's a sublease, if you have a loans, you're probably not too familiar with the landlord's loan documents, but you can look at your own. If you have any insurance policies. So for example, if you've had some damage to the property, maybe you can get some insurance coverage. You also want to consider the laws and regulations. And Wes was talking about evictions moratoriums. There's also in the city of Alameda some restrictions about the landlord cutting off your utilities for non-payment of rent. And there's some public health orders. And one of the strong reasons for these eviction moratoriums is not to help you as a tenant to win a lawsuit, but is to give you leverage in negotiations with the landlord, so that if that the landlord can't just evict you. It's basically designed to force him or her or it, whatever, to talk with you, and so it can give you some leverage in trying to work something out, which otherwise you might not be able to do. And it's an important consideration. So again, you're not acting in a vacuum. You've got this whole series of things to look at, and you want to kind of look at those. You may need a lawyer to that. You may need somebody to help you out with that. But in the first instance, read the stuff yourself. And if you look at it, you'll find that I promise you'll find some stuff that's interesting and most likely that you weren't even aware of, that can affect what you want to do in your lease negotiations. Other factor is think about the landlord. The landlord is not going to enter into a lease modification with you simply because he or she likes you or feels sorry for you. The landlord has its own concerns. A big one is lenders. In other words, it's got to pay, all these properties are subject to mortgages that the landlords have taken out in favor of lenders, and the lenders typically are expecting to get paid. Now, lenders obviously oftentimes are giving some breaks to their landlords because they have to because the landlords can't pay them. But a very important consideration for the landlord is not to go into default on its own obligations. Landlords these days are looking to minimize costs. So for example, if what you're asking the landlord to do as part of a lease modification is to spend $25,000 on your space to make it safer, and the landlord is going to you're asking the landlord to go out of pocket to spend all this money, that's going to be probably not really something the landlord's going to be particularly interested in doing, because again, it's got its own financial risk. Landlord's going to want to reduce its risk. And one of the factors in this regard is if it's going to be making a deal with you, it wants to have some reasonable comfort that you're going to be able to perform what you're promising. In other words, one of the cardinal rules of negotiation is don't negotiate one promise essentially for another promise when you figure then they're not going to be able to, the other party's not going to be able to satisfy the other promise, the new promise. So when you're thinking about with the landlord, it's not simply changing what the paper says. In other words, the landlord's not looking for you just to change the wording on the lease modification. What they're looking for is if you promise that you're going to do something, that you're actually going to be able to do it. And so that they're somewhat reducing their risk because they're getting a handle on it, saying that if I make this deal with this business owner, I can count out that's going to happen. And so therefore, I know I'm going to get this amount of money every month, and I worry about my other tenants, but I've got this. And so that's a really important consideration for landlords these days. And then of course, landlords would like to get profit. I think, right? I mean, that's what they're in business for. Right now, I think it's a little less of a concern than oftentimes, because what I think a lot of commercial landlords are trying to do right now is just to get through the current environment so they get out the other side and then make profits at the other end. But obviously that's always a concern. And so what you've done essentially is you've kind of gone through and with a piece of paper, or on the computer, you've kind of gone through and made a checklist of these various things, these issues. And you're understanding basically the playing field, where things are if you don't have a deal, what you're looking to accomplish, what the landlord is looking to accomplish. And what that'll do is that will help you kind of in figuring out how you want to talk with the landlord. What do you want to suggest? It really doesn't make a whole lot of sense to suggest something to the landlord that is completely off the wall as far as the landlord is concerned. But if you can tie it to the landlord's interest, to what the existing lease agreement says, or the existing laws say, and so that it makes sense from the landlord as well as perspective, as well as from your own, you're going to be much more likely to be successful in coming up with a lease modification. Anyway, that's my part. And I know, there are a lot of details that we can talk about and if people have questions about, but that's basically a structure for trying to negotiate a modification of your lease.
Thank you, Neil. So we are going to move into the Q&A portion of the discussion. Folks, we're asking you to put your questions in the little Q&A function at the bottom of the screen so that we can answer them. And the first question is, and there's actually two questions that are similar here. It's about whether there is a limit to the amount a commercial tenant's rent can be raised during lease renewal.
Take that. Unfortunately, no, unless there's some other special provision that's been agreed to in a prior contract whereby you secure an option to renew with some fixed percentage increase or some other mechanism. But as long as the negotiation is open to a true market reality, that market reality is going to play out and determine what the value of that particular piece of real estate is. And sometimes the timing of things works that the market has moved in the direction of the tenant, and other times a tenant may find himself in a situation or herself in a situation where the market isn't moving favorably to their interests, and rates are getting higher relative to where they were 3 to 5 years ago when they just worked through their last either new deal or renewal.
Yeah, I think in the residential context there can be some restrictions, but not in the commercial area.
And that was my understanding as well. I think most of the protection on rental increases have been in rent-controlled units or residential for the most part.
I will qualify again. I'm a commercial practitioner, so in my world, there's no such thing as those protections. But certainly, yes, in the residential multifamily, you do have those protections, and those are typically, regulated by individual municipalities, counties, etc.
So I think this may be a question for Ted. There's a question about current commercial space availability in Alameda. What is it? Do we know any availability projections over the next 6 months, average cost per square foot?
Loaded question, because it could involve all kinds of different classifications of property. In town, we tend to have, office, retail, and industrial, which are your typical basic major food groups in commercial real estate. Most of our industrial is really out at Alameda Point. and then concentrated kind of along Clement and Blanding, where, you know, historically we had kind of heavier industrial uses. And then office-wise, you know, you're looking at Marina Village is kind of an area and concentration of a lot of office product. And then certainly as you go out to Bay Farm, you know, in those markets, lots of new product coming out of the ground. If you haven't been out there of late, I mean, it's pretty impressive to see the amount of construction that's going on out there. And most of that's biotech and life science related, which is neat because it's kind of a new cluster that's forming out here. But, you know, rental rates in the space, you know, I'd say office wise, you know, you look at Marina Village and, you know, they're asking on office, true office space, $3.50 net to kind of $3.75. You know, industrial kind of varies very much on the footprint and size of what you're looking at. As there's economies of scale, the larger the footprint, the less you're going to pay on a per square foot. So, you know, a 20,000 square foot, you know, warehouse, if you could find it in Alameda, you know, probably trades at, you know, 90 cents to, you know, maybe 85 to 90 cents net, just to give you a feel. But you know, that is a very broad question. So apologies for a broad answer.
Thank you. Oh, go ahead, Eric.
If a person needs help in finding space, if they're searching for space, please feel free to contact us.
Oh, yeah. Thank you, Eric. Would you put your put the correct email address in the chat? So here's a question. I told my landlord I needed to terminate my lease. I rent 2 buildings from her. I can only afford 1. I brought her a new tenant who she signed a new lease before terminating my lease. Is that legal? Am I automatically terminated because of the new tenant's lease?
So it sounds like there was a sublease that happened, or that it was maybe going to be a sublease and then it turned into a direct lease. I mean, as long as a new direct lease was agreed to and you got a release or a termination agreement from your landlord that states that you no longer have any legal obligations under your original contract, I would say that you're probably okay. But, you know, if you didn't receive any sort of a termination or some sort of a legal document that ceases to have you and that landlord having any sort of a relationship on that specific property, I'd probably suggest that you look to get something like that. The implication being, if this new entity defaults and there's not a clear-cut understanding about, you know, that relationship, it could prove legally tenuous. I don't know, Neil, if you want to add.
Yeah. No, I think you accurately described the muddle, Ted. Yeah, there's a couple possibilities. One is that, yes, the landlord let you off the hook and then just found somebody else to lease the property. In which case, if that's what happened, then you're off the hook. Another possibility is the landlord accepted the fact you weren't going to pay rent anymore, and they went out and they tried to mitigate their damages. Meaning, okay, yeah, the landlord might take the position you've breached your lease, and so I'm trying to reduce my losses by finding somebody else to occupy that space. And as long as that tenant is paying as much rent as you are paying, then the landlord hasn't lost anything. You know, if they do that until the lease would otherwise expire. But if the if the new tenant is paying less rent, then under that scenario, the landlord may be looking at you for the difference. And just from the question, it's really impossible to tell which is which. I mean, which was really happening. And it probably is a good idea for the tenant to try to get some clarification from the landlord, just as Ted was saying.
Thank you. So this next one is for Neil. What is East Bay SCORE? Could you talk a little bit more about what your organization does?
Yeah, sure. East Bay SCORE is a chapter of the SCORE Association, which is a national nonprofit. It's affiliated with the U.S. Small Business Administration. And we are an organization that provides free business counseling to small businesses and entrepreneurs looking to start a small business. So most of our members, all of our members are volunteers, but most of us are retired business owners or managers or service providers. Like I was a partner in a law firm, so I was kind of a twofer. I was an owner of a business as well as providing services to business. And basically providing business counseling on a whole variety of things, ranging from business planning to marketing to how to do e-commerce, across the board. And as I said, the majority of our members are retired, but we have a fair number of people that are still working or working part-time. And so our service area covers Alameda, Contra Costa, and Solano counties. And we've been doing that in the East Bay since 1982. And as I said, it's free. There are no limit on the number of counseling sessions we provide as long as we're actually making progress with the small business owner to help them decide what they want to do.
So Neil, is the best number for East Bay SCORE still 510-273-6611?
Yes, that is our office phone number. They can also go to our website, which is eastbay.score.org, which gives you more information about it, and our email address as well. Our office is actually at the College of Alameda, although we're doing a lot of counseling virtually, by Zoom or by phone or by email as well.
Thank you, Neil. I put that information in the chat in case people want to reach out. I know East Bay SCORE is a fantastic resource for Alameda businesses. So here's another question about, this question is about evictions. Can I evict if a tenant fails to open for business?
This kind of falls into the question of why the tenant's not opening for business. The normal answer to that is if the lease says they're supposed to conduct a business. You remember I was talking in my presentation about lease provisions about paying rent and then other provisions in leases. And this kind of falls in the other category. And so the answer really depends to a large extent on what the lease says. If the lease says you must conduct a business there, then their failure to do that means they're not complying with the lease. If all the lease says is you're just going to give me a certain amount of money per month, and you don't do that, then and the fact they haven't opened the business doesn't really is the problem as long as they're paying the rent. So maybe if this person can kind of give a little more information, I can give a little more complete answer.
Thank you, Neil. Yeah, hopefully that person can maybe put a little more information in the Q&A function. So the next one is my landlord is forgiving 33% of past rent of $42,000. Should I negotiate now for a rent forgiveness if we are shut down again? I had to battle to get the 33%.
Ted, why don't you take a whiff at that one?
Yeah, I will. I mean, it's always kind of a judgment call. I mean, these become kind of interpersonal discussions, really. And so you really need to kind of read your audience, and that read is probably, best had by your experience with that individual over however long you've been engaged doing business with them. But in my experience, my landlords that I have done a lot of work with are all too willing to have a first discussion. And they think that's a really good idea because, typically serves both interests because they want to maintain their income stream. And, they want to maintain your tenancy. You want to maintain your tenancy and your viability of your business. But there is a point at which the landlord gets concerned that there is no point of recovery to be reached and that, your tenancy is just, going to eventually become a net loss. So the harder and further that you push for concessions, you just need to understand that is telegraphing to your landlord that trouble is continuing, you're not righting the ship per the original plan, and that's typically not a good sign. So I would just leave it at that.
Thank you. All right, so the next question is, have you seen anyone having success with negotiating a sliding scale adjusted lease term when entering a new space? Like if I wanted to rent now, but have rent start lower and adjust upwards as business normalizes.
Yeah, I mean, we see those kinds of lease constructs. I will just tell you that the market, generally speaking right now, and it's going to sound kind of strange, but since the middle of March, there was really a pause, like you don't typically see in market. Markets don't just all of a sudden pause. And that pause has created, kind of a little bit of a fog in the market because, we haven't seen a lot of comparative leases and comparative sales since the COVID, circumstances began. So it's really hard to peg a trend line on where the market's going. And so as we sit here in late 2020, there's as many landlords out there that feel, oddly enough, bullish about where things are going in the future, or not necessarily as scared about what the future holds, where tenants, are pretty darn certain that things are bad and likely getting worse. And so with that difference of opinion, you kind of have a market where, some landlords, depending on your product type, are willing and concerned enough to consider those types of unique lease structures, but we haven't seen a lot of it adopted just yet. I don't think you'll see a lot of it in the industrial space. In retail, perhaps, office certainly, where I think you're likely to see a weaker market, continuing to show itself as we move into 2021. I think it's fairly safe to say that, those particular segments of the commercial market are likely to see ongoing pain, and there's likely to see, further weakening of the market in those particular spaces. But I don't know if that helps to answer, but.
Thank you, Ted.
You're welcome.
There is the gentleman who had the question about evictions has come back with more information. He said that the lessee has failed to reopen after shutdown and will not respond to phone calls or letters. Lease requires regular business hours and good conduct of business.
Okay, I think this is maybe a question for Wes, because although there is a restriction on evictions, my understanding, and I know Wes is more of an expert on the city of Alameda ordinance than I am, is that it doesn't restrict evictions for everything. It's only for certain things.
Yeah, so the ordinance 3275, the protections provided in that are primarily based on the lack of payment of rent. And my understanding on the question is, it sounds like if the eviction was to be based on another term in the lease not being fulfilled, that would not fall under the ordinance as it is currently written.
And one thing that's obviously important is if there's a public health order that prevents the tenant from opening or doing things, then I don't think they can be evicted for having complied with the public health order.
That is correct too. Yeah, it's because to put that in context, the public health, if a public health order, it's still linked to the substantial loss language. So if a public health order is causing or requires let's say a bar or a restaurant to close, and a bar and restaurant closes in compliance with that public health order, that kind of factors into the proving up the substantial loss needed to access that affirmative defense as written in the ordinance.
Yeah, but if for example, under the public health order, they're allowed to open and they've just decided essentially to abandon the premises by just not doing anything, that probably is you know, that might be sufficient to take action against them.
Yeah, that probably, unless without more, that probably falls outside of the ordinance as written.
Thank you, guys. All right, so the next one is, my business is engaged in a 5-year lease. I'm spinning off a subsidiary of the business that I would like to take over the lease. What is the best way to negotiate the transfer of the lease to the new entity and release my business, who is currently obligated for 5 more years?
I think the best way to do that is to look at your lease and see what it says. Most commercial leases cover that kind of situation and talk about the circumstances under which a landlord may, must, or may not consent to an assignment of or transfer of a lease and what happens. So I think your starting point is to see what your lease says. And then once you see what your lease says, you may conclude, oh, great, that's exactly what I want. And if you want something more than what the lease says, in other words, you want the landlord to do something beyond that, then you kind of figure out how can you sweeten the pot for the landlord so the landlord is going to be willing to give you the extra. Is that pretty much your take as well, Ted?
Yeah, I mean, I would just say, you know, when you're talking about a new subsidiary company, right? I'm assuming it's of lesser credit than probably the originating, you know, lessee, and so assignments, you know, to a lesser credit entity sometimes become a little more difficult for a landlord to accept. In which case, you know, the sublease function would probably be, you know, the means of granting that new entity legal right to that space, but it would not, as you are looking to do, absolve your you know, original company from the liability of that 5-year lease.
Yeah, yeah. A typical, again, you have to look at what the lease says, but a typical provision, kind of focusing on what Ted was saying, is that the landlords will, again, in the commercial context, the landlords are obligated to agree to an assignment, provided that certain conditions are satisfied, including, you know, the new owner is going to be using the space for essentially the same stuff as before, and has at least equal credit worthiness of the original, you know, the original tenant. And basically, the idea is the landlord's not going to be harmed by the assignment. And they can't just arbitrarily say no because they're just unreasonable people, but they generally have a right to not be hurt by it.
Agree on all points.
Thank you, guys. So this next question is about whether a commercial frustration clause could be used. So the questioner says, my lease is strictly for a beauty salon because the government said we could not operate March through September. Could a commercial frustration clause be used? Now my landlord wants to modify lease to say I am a retail business instead of a beauty salon, so I can't claim commercial frustration in the event we have another shutdown. Landlord will not forgive any rent if I don't sign the lease modification.
Well, I can't speak to the provision that she's speaking to. Just not familiar with that. The frustration clause, is that, Wes, do you know anything about that?
Yeah, it's unfamiliar to me as well. It may be specific to that particular lease. I will say though, 3275 doesn't really obligate a landlord to forgive any rent whatsoever. It doesn't alleviate any obligation to pay rent. So any kind of talks between that particular tenant and the landlord, there's no legal obligation that requires the landlord to forgive any rent.
Yeah, I would be a little uncomfortable with the idea of agreeing to something in a lease that's not true. In other words, if you actually are going to be operating it as a beauty salon, changing it to say you're not going to be operating it as a beauty salon when you in fact are going to be operating it as a a beauty salon is not really a good thing, because you want to make sure, because that you're not doing yourself any favors, because you're going to be found, if you change the language to something other than what you're doing, then if you're still doing it, then you're in breach of the new lease. So that kind of gets you in a in an uncomfortable position, because you're promising something that you're not going to be able to do, and that tends not to be a good idea. On the commercial frustration, there were some comments. I think commercial frustration is a concept that I don't really think is probably applicable here. You're really more talking about, I think, what's oftentimes referred to as force majeure, I mean, an act of God. And so something that happens that, and a public health order prohibiting you from doing something falls in that category. So whether your failure to comply, for example, the failure to keep the store open when there's a public health order that prohibits you from doing that. And this is the kind of thing that's objectively impossible. In other words, nobody could keep the store open because there is a public health order preventing it. That can excuse you from having to have a beauty salon there, operate a beauty salon, but it doesn't excuse you from paying rent, because the rent, if somebody is sufficiently wealthy, they can pay the rent. So it's not objectively impossible. I don't know if that answers the question, but it sounds like what's happening is the landlord is trying to give you a break on, or is offering to give you a break on some rent, but then wants something in return that you really can't give, meaning that you're promising to, you're promising to use the space in a way that wasn't intended. This, again, not really knowing anything about this, but you potentially have the situation that Wes has been talking about with the eviction moratorium. In other words, if a landlord is putting you in an untenable position, and you can't work something out, maybe the eviction moratorium is something to hang your hat on. I don't know. I mean, I don't have enough information to have an opinion about what would be the best for this person.
Neil, there was a clarification in the chat about the phrasing that it should be frustration of purpose and impossibility of performance. Does that ring a bell or change any of your answers?
Well, the impossibility and force majeure is the same thing. Yeah.
Okay.
And again, it's I don't want to go into too much detail, but it's the idea when the impossibility is the concept of objective impossibility. Nobody could do it. And so if there's a public health order that says nobody can operate a beauty salon in that spot, then that applies. Okay. And I think that's kind of consistent with what I was just saying.
But my view, just with the limited information, is kind of in line with what Neil thought. I mean, it sounds like this landlord's trying to trade an economic concession for a contract reality that would put this tenant into default, at a future point in time more easily, thus creating a situation where, there would be a greater legal trouble to kind of consider. So I would advise, if that's what's going on, to rethink agreeing to that.
So there's a clarification here. So a force majeure can get you out of your lease, but has no impact on the obligation to pay rent. Is that right?
Okay, that's a little overbroad. If you have a particular covenant or a promise in a lease that says, I will operate a beauty salon and keep it open from 9 a.m. to 5 p.m. with an occupancy of 40 people, and you have a public health order that prohibits you from doing that, that can excuse you, because it's objectively impossible, given the public health order, from fulfilling that term. It doesn't mean it gets you out of the lease. It just says you can't be held in breach of the lease because you didn't do that one thing. But the problem, and this is why it really isn't terribly helpful for most tenants, is it's not objectively impossible to pay your rent, which is really what most leases are all about. Because if you are sufficiently wealthy, you can pay your rent even if you're not operating. And so there's been a lot of discussion about impossibility and the concept of commercial leases. But I think the reality for most people is it really doesn't get you out of get you out of your obligations, because at the end of the day, the fundamental thing with a lease is paying money. And that's not objectively impossible.
Thank you, Neil. The next question is, I have a largely absentee landlord without any way to reach them. We've requested rent concessions and had one discussion since the shutdown. She said she would get back to us and needed to take time to consider what was possible. We've never heard back from her again. What are my rights relative to what's owed? Am I 100% tied to my monthly rent?
Yeah.
I will
Yeah,
say,
please.
oh, sorry, Neil.
No, please go ahead.
Yeah, so as written, and as you saw in my slides, unfortunately, Ordinance 3275 does not alleviate any tenant's obligation to pay rent. What it does is, like I indicated, it provides an affirmative defense for eviction proceedings should those proceedings go forward. I don't know if that answers your question, but as far as your obligation to pay rent, that still remains. It is unaffected by any of the state or local laws that have been enacted.
Now, one thing, obviously, we can't, and I assume everybody understands this, we're not giving legal advice to anybody in this program. I mean, the information, besides the fact we couldn't do it anyway, the information we're getting is sufficiently sketchy that, we don't have the whole story. So hopefully everybody understands that. From a hypothetical strategic thinking, is one of the benefits of a ordinance like the city of Alameda has is it is a way to get the attention of landlords. And so again, I'm not recommending anything to anybody, but if you have the financial inability to pay the rent, there are regulations that the city of Alameda has come up with within that ordinance about that the West obviously would know better than I would with the specifics, but I mean, they're publicly available, about you give a notice to the landlord of certain things, and either you don't pay rent or you pay the rent that you're able to pay and so forth. Essentially follow the language of the ordinance and the and the city's regulations dealing with it. And in broad strokes, if my memory is correct, it's basically saying you pay the rent that you feel you can pay. And if it's less than the full amount, you do that. Now, that doesn't mean that the rent is forgiven. I mean, ultimately, it doesn't mean that you never have to pay it. But the landlord can't evict you, assuming that you meet the requirements of the ordinance. The landlord can't evict you, and for some extensive period of time. And so, who knows what's going to happen in 6 months from now or 9 months from now. And the landlord is getting less money because you're giving them less money. And that can be a way of getting the landlord's attention, maybe to talk with you. Again, the rules that the city has come up with, the regulations actually, and I think there's actually you would know this better. There's actually a form letter, I think, that the city has come up with, and so you take a look at that, and because sometimes in negotiations, and I've had this experience, and I'm sure you have as well, Ted, is sometimes the most important part is just getting somebody's attention. And, you know, you say pretty please and nobody pays attention to you. And sometimes you have to do something a little more aggressive. And if you can do it within the you know, an established structure, that's so much the better.
Little pain usually makes people come together.
Yeah, the forms that Neil mentioned are on our city website. They are essentially like these forms that the tenant and the landlord can kind of fill out to kind of work out some agreement to pay a partial amount of rent. It is on our tenant resources website, on the main city website as well.
We also put that link in the chat for folks. So kind of a continuation of that theme, can I terminate a lease if a landlord refuses to be available? I'm not provided any contact information.
What does it mean by be available? I mean, presumably, what does it say in the lease? I mean, presumably in the lease, there's some address or notice provision for the landlord.
Well, let's give that person maybe a minute to chime in with that, and I'll go to a different question. Any feel for the number of businesses Alameda has lost since March?
I think this is an Amanda or Eric question.
So this, Eric, do you want to take this or should I?
This is hard to come by in terms of retail businesses. Some businesses have closed due to the pandemic or waiting until they're allowed to reopen. So it's unsure if they're temporarily closed or if they're permanently closed. Also, in terms of some of the larger businesses that have filed with the EDD and with the County Workforce Development Board, we have seen some of those notices, but not every business files those claims. So we really don't have any concrete aggregate information.
We are trying to track it as we hear of places that are permanently closing, but it's a very informal list. And as Eric was saying, it's pretty incomplete, I think. I don't know if anyone else, the other panelists have thoughts on that or have any information. So the next question, or Madeline, was there something you wanted to say?
Yes, according to the workforce of Alameda County as of October 7, she said the impact was on 16 businesses, but not specifically who. And the assumption is a lot of businesses, like Eric said, are not really reporting their process of closing or anything like that. So she had only 16 total as of October 7.
And just also in terms of businesses in Alameda, the pandemic has affected different types of businesses and industries differently. So some businesses have been and sectors have been really impacted by the pandemic, like personal care services, and while other businesses have largely been unaffected, like life science. It seems like that those are doing continue to do well. So it's very uneven too.
So we've got some more information from the person with the absentee landlord. She's saying her landlord has a personal issue she is battling and has disconnected all ways of contact with her for more than a year, causing her to miss opportunities and not allowing the tenant to move forward with work on the physical building because she cannot reach her in any way. This has been going on for over a year.
Well, I think there's kind of two issues. One is a legal issue and one is a practical issue. From the legal standpoint, it's looking at what the lease says. In that, if the landlord is fulfilling the landlord's obligations under the lease, the fact that you might not be able to get hold of her doesn't make it a legal problem. If there's something in the lease that the landlord is obligated to do that the landlord isn't doing, then that can be a a basis for a legal claim. Ted, maybe you have some thoughts about kind of the practical issue, because I mean, I can talk about filing lawsuits and all that other stuff, but that's crazy. I mean, that's not really going to be very helpful for anybody.
Yeah, no, I mean, this is kind of a weird situation, because most landlords want to be good stewards of their buildings, and they want to, have a good relationship with their tenants. So I agree with you largely, Neil. I mean, your lease is kind of your roadmap to, your rights, legally to compel a legal, means of getting this solved. But when you have somebody that's going through, as you explain, a deep personal issue, and they've kind of closed themselves off from the world, oftentimes you might want to look, to see if there's any other, family members that you might be able to get in touch with that would have, a close enough relationship to help you out, or at least give you some guidance on how to move forward. Because I certainly can appreciate the frustration in this, but it's rare, I would say, in my 20 years. I mean, people will go kind of missing for a few months because people travel, things happen, but an ongoing year-long absentee, no communication whatsoever is a strange one for me.
Thank you, guys. So we've got just about 2 more questions. If there's other folks on the call who want to ask questions, please get them in the Q&A box now. The next one is, what is your take as well on the law regarding load factors and CAMs? My landlord has built in a 15% load factor for the last 20 years. He hired a new accountant recently who decided to add CAMs. Is it common for there to be a load and CAMs? Can I fight this?
Well, the legal answer is it depends what the lease says, but Ted, maybe you can give more of a practical answer.
Yeah, no, it's definitely, there's so many different types of lease. There's different lease types, right? And so different lease types, give way to different lease structures. And this is a little confusing because it sounds like kind of a full service construct, and then he's kind of throwing in a CAM or something like that. I don't know. It's hard to get it at the realities of the document, but there is no standard to load factor. Every building is its unique little jewel box, and some are more efficient than others. So there's BOMA, calculations and standards that are utilized to kind of determine, rentable and leasable square footages. And you can certainly ask your landlord to provide those at a point of renewal to ensure that, you're paying for exactly what you're getting. But to my knowledge, I mean, there's no legal, percentage you have to adhere to as it relates to that. And CAM is common area maintenance, and that's typically a component of a triple net operating expense. So, if you're under a net lease, you have a base rental rate that you're paying, and then in addition to that, on a monthly basis, you're paying your share of property taxes, insurance, and then the CAM, or common area maintenance charges, for the upkeep of the building. So, that's not a weird thing to have as a component of the operating expenses that you'll pay in a given month under a net lease. But if you could give us a little bit more clarity on the type of lease you're operating under, it might help us.
I think he just offered a little more clarity. He says the lease is full service, not triple net, and the lease does not mention load factor. The landlord just doesn't.
Well, I mean, if you're paying on concepts that don't exist in your lease, that's a problem. But again, it's going to be tough, I think, for myself and Neil to get to the meat of this without a review of the document and an understanding of what the rights under that lease are of this landlord. But if you say, as you contend, that there's no right or basis for these charges, it would seem to me that you've got a right for a legal battle. Neil, what do you think?
Yeah, the problem with this, and this is not an invitation to show me the lease, because I really can't be in a position to give you legal advice, but you might want to see a lawyer. is clearly the landlord can't charge you for something that's not authorized by the lease. I mean, that's a tautology. I mean, you just say that. You know, for example, if the lease says your rent is $100 a month, the landlord can't charge you $200 simply because the landlord wants to do it. Presumably, however, the landlord has some justification for why what he's charging is covered by the lease. I mean, most landlords are not going to simply charge you something and then say, when you ask them why, say, well, I just felt like it. I mean, they're going to probably tie it to something in the lease. And then it's a question of looking to see whether this really actually does meet something that's in the lease. And yeah, I mean, that's frankly, that's what, you know, again, I can't do that. But what you might want to do is have a conversation with the landlord and saying, you know, I've looked at this lease and I can't figure out where it is that you think that you have the right, say it nicely, but, you know, but say it that I can't figure out where you think in this lease you're entitled to charge me this amount for the load factor. Please clarify it for me. And my guess is the landlord will point to something. And the landlord's probably not going to say, I just made it up. But if he does, then you got your answer there. But we'll point to something, and then you can kind of decide what to do from there. Is, oh, yeah, that makes sense. Or maybe I should talk to a lawyer about it.
Thank you, guys. We're getting a lot of kudos for the panelists in the chat box and appreciation for your information and thoughts. So we're down to our last question. Any advice on how tenants should plan to deal with the massive increase in their triple net leases if Proposition 15 passes? Can you give an insight for tenants to get prepared for rent increases?
It's going to be interesting. It's really going to change, you know, the playing field for commercial real estate. And it affects, you know, buildings, I think, only over $3 million in terms of assessed value. And it's going to be phased in, as I understand it, at least as it's being proposed. So it's not, you know, immediately going to come into effect. You know, if it passes in November, it will be a phased in change. But what it's going to do is, you know, it's going to take away the low cost basis advantage that landlords have over other landlords when they've owned something for a long, long time. It's going to create, you know, a property tax basis that brings everything to a more even playing field. So if you've been in a building, you know, that's been owned and operated by a family for 20 or 25 years, you know, you should expect that you're probably going to see a more significant increase in those expenses. If you happen to occupy a building that, you know, has traded hands frequently and that property tax basis has been stepped up, you know, every 5 to 7 years by just typical investor churn and traffic, you know, those realities aren't going to have as dramatic of an effect. So you really need to just pay attention to the realities of your landlord and how long they've owned that building. Because that's going to really be, you know, your best guide to understanding how big of a concern this could or will be. So I'd leave it at that. And I don't know if Neil or Wes have anything to add.
Yeah, well, yeah, just the point you just made. It's both how long they've owned it and also the value of the building. Because I think you know, for some of the properties that tenants, you know, small businesses may be using, they may be below the threshold, so that you know, it really won't affect them. And so it's, yeah, just kind of looking at the specifics.
Yeah, and I think that is it 3 million? Is that what the mark is? I believe if the value is above 3 million, it's subject to reassessment, and under, I don't think it is.
I don't remember what the number is.
Yeah. Anyway, but don't take that for gospel. Read your ballot.
There you go.
And vote.
Amen. All right, well, we've gotten to the end of all the questions. And I do, you know, Neil mentioned this, but I do wanted to just reiterate that this is this webinar is for informational purposes only, does not this is, not legal advice. So please take it, for what it is. And I want to thank all of our panelists and presenters. We really appreciate you all taking time out of your day to share with the Alameda business community, to go through these. It's been a lengthy Q&A session, but I'm already getting a lot of kudos from folks and thank yous coming into the chat box and the Q&A. And so I think this has been very, very helpful. Just to the participants, thank you so much for watching. This is being recorded. We're gonna post it to the city's website. I'm also gonna follow up with all of you with just an email with some of the resources that were included in the chat and a link to the recording in case you wanna share it with anyone. So anyone else have anything before we say goodbye?
Just thanks to you, Amanda, for setting this up, and Eric as well. It was great to be a part of the panel.
Yeah, and also Madeline, thank you for the Alameda Chamber co-sponsoring this with the city.
And I want to thank everyone for including us as well. Thank you very much.
All right, thank you guys. Bye-bye.